Order benchmark. Seal number authorized seal number 1. Rajita, look what sample ka.
And for respondent number one.
What are the steps to be taken in respect of unserved? Why you moved a slip, move a memo?
No, I am not moving.
Who has moved? Where is the respondent?
Petitioner.
Acknowledgement received but signature name does not tally with the petition.
Adequate, my lord. In this case, may I invite our last kind attention to the order dated 18/4/2000.
You are for the respondent.
No, I am for respondent.
Where is the counsel for the petitioner?
Ranjita.
You represent?
I represent respondent number 1 and 3, my lord.
Who is two? Who is two?
Who is the son of respondent number 1, my lord. But point is the respondent, the present petition is also absent before the trial court. Adequate, there is an order passed by this honorable court on 18/4/2023, directing the petitioner to deposit 50% of the amount, my lord.
Not deposited.
He has written non-compliance of the order, my lord.
Interim order is there.
Yes, my lord, interim order is there. He has not deposited the interim order.
Where is the counsel? See, is he online?
No, my lord.
No.
It is submitted by the counsel for the petitioner. A respondent that the order dated 18/4/2023 is not complied with. There is no representation on behalf of the petitioner. By 3rd of December, if the amount is not deposited, the stay granted by this court, dated so and so, stands vacated without further reference to the court. Yes, next.
Seal number 2. RH Changi.
Huh?
Regard to delay date are not mentioned in the application.
What is that?
Delay
Delay
date.
date in the petition are not mentioned by mistake. And one field is not properly. Those are the two options. I will apply it to those options. Notice my candidate, there is a delay in filing
Yes, yes. Notice the respondent.
Please.
And the petitioner shall comply with the objections during the course of the day.
Please.
Hearing on I. Seal number 3. This is Bawakhan. This is Bawakhan. Seal number 3.
No representation is this matter on Monday.
For discussion, seal number 4. J. Shetty. Subhash Jabati.
You appear for the respondent. What is his name? Subhash Jabati.
Subhash Jabati. SP Shandha. No.
No. Yes. Is there interim order?
Yes, regularly, my lord, is
Paying?
4,000, my lord.
The counsel for the petition submits that as per the order passed by the court, he has been regularly depositing the amount. The respondent is at liberty to withdraw the amount.
Not deposit, paying directly.
Paying. He is regularly paying the amount. No representation for the respondent. This is matter after winter vacation. Interim order already granted is extended till then. Delete from the caption for dismissal.
Seal number 5. Veracious. Got it? Seal number 5. Veracious.
No representation. Oppose this matter tomorrow. Yes.
Seal number 6. Admission button.
No representation. List this matter after winter vacation. Yes.
Seal number 7. Very good.
Already filed objection. In second division, already filed objection yesterday, my lord.
Yes, sir. I'm ready.
My lord, for that I make one submission. Like there are three cases pending before the family for Dharwad and Dharwad. In the maintenance section, we appeared. And my matter record to the conciliation. Conciliation, but likely to be settled.
I don't have any instructions regarding that. There is no settlement talks till today, Maharaj.
When counsel for the petitioner submits that the matter is likely to be settled, this is matter of certification. The more order granted in that standard. In interim order is in 7. Yes, next.
Still number 8. Nagarata
No representation poses matter after occasion. Yes.
Still number 9. Ganesh Rai Bandi. Prithviraj Vittalmani.
No representation after winter vacation on behalf of both the parties. Next.
Still number 10. LV Hireman. Central Court.
The petitioners still have not complied with the order.
What order? What is
For that hearing of that easementary.
They have not done.
No. This photo was taken today morning. They still have not yet cleared.
Where is the council? Any interim order in this?
Yes, also.
No.
No
They
interim.
have filed I for saying this and.
Court has not granted any.
No.
Yes. This is matter, no representation. This is matter, no representation for the petitioner. This is matter after winter vacation.
Still number 11.
Yes. Calling.
Yes, Harikeri. Still number 10.
About 70% of the,
He's showing the photographs, please see.
Yes.
No 70%.
please. Alive. In the morning I have received.
He also received in the morning, it seems.
So it was taken on 7 in the morning today. They have only cleared the pathway for going there.
Lord, I have instructed them to clear the end. Unless and until the entire encroachment is clear, no order will be passed by the Honorable Court. I have instructed them.
We'll say this is matter after winter vacation.
That would be too long. Then the entire 3 months of their.
They'll happily be there in the, without coming out. So when the court is giving you an opportunity,
Hello,
why are
that
you
is-
not
that
doing
is-
it?
They have
This
to-
is matter on 9th,
Please.
9.
and on that day, appropriate orders will be passed,
Yes.
no further time will be granted.
Please.
Yes.
Still number 11. Yes, Harikeri.
No, it's a counterclaim against a counterclaim is filed in the suit, my lords. The fact that leads, I may.
What is the
explain.
suit for?
It's a suit for partition.
Suit for partition.
It's a
What is the
suit.
counterclaim?
Now, your lordship may kindly take page 55. It's a genealogy. I will explain through the genealogy so that it would be familiar. Page 55. This is not the actual suit, subject matter suit, but only for genealogy I am referring. So that this Gangappa, he had a son Chandrasekhar and Neelappa. Then my lord, wife Parvatava, etc. Sons Veeresh, Suresh, Bhagirathi and Murugesh. This Murugesh my lord has filed a suit now. Now what he has filed a suit is my lord that he has excluded this Neelappa. He has filed a suit on the my lord, assumption or my lord pleading that
Where is
there was a
Neelappa?
par-
Neelappa.
there was a partition between Chandrasekhar and Neelappa. As such, the properties has come to the share of Chandrasekhar, so that in that property, the Murugesh and others,
According to him, already there is a prior partition between the brothers.
Yes.
So he sought for partition of his father and between father and brothers.
yes.
Uh,
Now, my lord, this Suresh,
mm.
who is a degree here, my lord, he filed a counterclaim and he said, my lord, that there is no partition between this Chandrasekhar and Neelappa, both brothers. There is no prior partition as such, so all property should be included.
Why should there be according to him in the partition suit, even Neelappa's property should be included.
And my lord, he made a counterclaim there. This Suresh made a counterclaim there. That my lord said some of this Neelappa had given him the properties. Those properties should also be made a subject matter of the suit, and then partition may be granted, etc. My lords. Then interestingly, my lord, this Neelappa files an impeding application in the suit. In the impeding application, he says that there is no partition in the family, and I also be impeded there, and also the property should be brought on record, and everything should be partitioned to us.
That was rejected, but this High Court in the DMCPC writ, my lord, allowed it. He was impleted there. Then, my lord, these people what they do is
High Court order is as far as impleading is concerned.
only impleading.
After that, now the counterclaim has started.
Now, after this Nilappa dies.
Hmm.
Before he files the written statement, he dies. His wife comes on record. Now, my lord, these plaintiffs, my lord, through her, they have got a counterclaim filed against the counterclaim that was made by Suresh Millards. In that, my lord, your lordship may kindly take the counterclaim.
Same as taken by Nilappa, that it is not partition.
No, my lord, she says there is a partition. And she be declared as an absolute owner of the properties of her husband, contrary to the IA. In fact, when the trial court dismissed the
Contrary to the stand taken by the husband, who is concerned with the property.
Yes, ma'am. And interestingly, my lords, when that IA for impleading was rejected, he filed a separate suit, my lord, seeking the partition in the entire properties. Since this High Court allowed in the GMCPC that IA, he has withdrawn the suit. So all through, my lords, in the IA and these separate suits, inconsistent stand is the number one.
You appear for whom? You appear for Murugesh?
No, my lord, I appear for, my lord, this Suresh, my lord. Who also said, my lord, as my lord,
he is the one first filed the he is the one filed the counterclaim.
Yes.
For this counterclaim, again Nilappa's files another counterclaim.
Another counterclaim, and she also makes a claim, my lord, that some of the properties.
That is allowed now.
Now that is allowed.
Let
No,
please come to the
counterclaim is not allowed. That I filed an application for rejection of that because the lordship may take that counterclaim, which does not, my lord, has a cause of action, anything. That page 61.
60?
61. Your lordship will kindly see this counterclaim. Here there is no cause of action shown, there is no pecuniary jurisdiction shown, and kindly come to the prayer words. And as I said, the contrary stand is at paragraph number 2. Contrary to what her husband said, she has taken a stand at paragraph number 2, that there is already a partition.
Under which provision you find this?
My lord, I filed under, my lord, 711A that there is no cause of action shown. Because in the prayer, what she says is, some of the properties that her husband had given me, that be declared as null and void, which is not neither the subject matter of the suit nor the subject matter of my counterclaim. So that's entirely a different thing, that what her husband gave me.
That counts for the petitioner. Submits that with the family, the trial court, without considering the application filed under order 7 to 11. In the proper perspective, had dismissed the same. It is submitted that the respondent here has filed a counterclaim which is unconnected with the issue that is involved in the case, and the counterclaim that is filed by the petitioner hearing. Considering the submissions, they should display a call for the proceedings on the file of so and so. The petition is permitted to take out notice on the and summons on the counsel appearing to the respondent and shall file a memo to the defendant. This is matter on 17th of December. By that time, the memo shall be filed.
Thank you.
Yes.
Still number 4.
Yes. How much is the amount?
8,000 to wife and 12,000 to the child.
8,000 to wife and
12,000 to the child.
20,000 is granted. What is your income?
My income is 42 as per the
42
as per exhibit R1 seller street. Now the court assumes it has by its own means overlooking that and saying it is at 60,000 at paragraph 1. 60,000 maintenance which is on higher side. Now wife has filed a divorce, not sure we are divorced now. I have taken second wife, living with my wife and child in Bombay. Now,
pay 15,000.
please.
Then counts for the petitioner submits that the court had granted maintenance of an amount of 20,000, which is on the higher side, and without considering the statement of assets and liabilities filed by the petitioner. Considering the same, they shall receive a fault for the proceedings pursuant to the ordinary so and so, on the condition that the petitioner shall continue to pay an amount of 15,000, that is 5,000 to the wife and 10,000 to the son, and shall deposit the arrears at 15,000 within 8 days from the date of receipt of the copy of the order. The petitioner fails to comply with any of the conditions. The stay granted by this court stands vacated without further reference to the court. Registry is directed to issue emergent notice. Next in that, on such deposit, the respondents can withdraw the same.
Please, okay.
Yes.
Serial number 30, Jagdish Patil.
Of the petitioner, an honest mistake has happened from our side. But we sincerely are sorry, madam. Before moving in our petition procedure, we moved the petition.
This is matter when?
Next week on Wednesday or Thursday.
This is matter on Thursday, the request of learned counsel petition.
Sorry, madam, please.
Yes.
Serial number 14. Ramesh Patil.
You have the stay. No representation for the respondent. The counsel of the petition is present. This is matter after winter vacation.
Serial number 15. SS Niranjan.
Wife's petition, wife filed a restitution control right before the candidate court.
From where to where you're asking?
Bangalore to Hubli.
Bangalore to Hubli.
The husband filed a divorce petition before the Bangalore family court.
Hmm.
Wife filed a restitution petition before the Hubli family court. There is a 1.5-year baby girl is there.
Then counsel for the petition submits that the wife has filed the MC seeking restitution of conjugal rights in the family courts at Hubli, and the husband has filed the MC in the family court at Bangalore. When was that?
On 3rd, 12th month for objection.
2024.
2024.
Filed MC seeking divorce on the file of the family court at Bangalore. He submits that the wife has to take care of a girl who is 1.5 years old, and it's difficult for her to travel all the way to Bangalore. Hence, there shall be, in view of this, like considering the submission, there shall be stay for all further proceedings on the file of so and so, so and so. The petitioner shall take out hand summons on the counsel appearing to the respondent before the trial court, and shall file a memo to that effect. This is matter on 18th of December. By the time memo shall be filed. Yes.
Serial number 16. CS.
Answers have been taken on the council appearing for responding.
Yes.
To the trial. If I'm not-
But already the cause list shows that it is served.
Sure. Sir.
Served, yes.
Petition is filed by the wife and seeking transfer from Vijayapur to Bagalkot.
What's the distance?
90 kilometers is the distance number.
When is the MC?
Yes, ma'am.
MC is of which year?
2024 miles. Both are 2024 miles.
You filed for restitution.
Restitution.
At,
Husband has filed, at Bagalkot.
Mm.
Husband has filed for dissolution of marriage.
The present petition is filed seeking transfer of MC number 64 of 2024 pending on the file of the first edition principal judge, family court Vijayapura to principal judge, family court at Bagalkot. The facts of the case are that the matter was formalized on 27/4/2018. In view of the differences between the parties, the respondent had filed MC number 64 of 2024 on the file of the first edition principal judge, family court Vijayapura. And the wife had filed MC number, what is your number?
137 or 20. 37.
137, 130 MC 137 or 24 on the file of the family court at Bagalkot. Any children out of in the wedlock, it is submitted that the distance between both the places is about 80 kilometers, 90 kilometers, and it is difficult for the wife to travel. Next, though notice is served on the respondent, there is no wakalat filed on behalf of the respondent. Considering the fact that the distance between both the places is more than 90 kilometers, and the wife has already filed a MC for restitution of conjugal rights at on the file of the family court at Bagalkot. Considering all this, this court deems it appropriate to pass the following order. Accordingly, MC number so and so, pending on the file of so and so, is withdrawn and transferred to the family court at Bagalkot. Yes, next.
Serial number 17. Legal party.
Yes.
So raise petition seeking the transfer the NC petition from Bangalore to Koppala, madam.
Kopla.
Koppala. More than 450 kilometers. Madam.
Which year is the MC?
NC 2034.
What is that for divorce husband file?
Husband and divorce.
You are a resident of Kopla. Land counsel for the petition submits that the husband had filed the MC seeking divorce on the file of the family court at Bangalore, and the wife is a resident of Kopla. The distance between both the places is about 450 kilometers, and it's difficult for the wife to travel. Considering the same, there shall be stay of all further proceedings on the file of so and so, so and so. The wife, the petitioner and counsel for the, till the next date of hearing, the counsel for the petitioner shall take out notice, hand summons on the counsel appearing for the respondent for the trial court, and shall file a memo to the effect by 17th. Yes, next. If it is not filed, we'll vacate the stay. Yes, 18th.
Seal number 18.
Wife's petition for transfer from Navalgund to Tungo. Distance is 80 kilometers. Earlier, the wife filed a petition for maintenance. Then the husband filed a petition for restitution of conjugal rights. It's transferred from Navalgund to Tungo.
MC is which year?
24.
Land counsel submits that the husband has filed MC seeking restitution of conjugal rights at
Navalgund.
what is the name?
Tungo. Navalgund.
So and so, and he submits that the wife is a resident of
Tungo.
the distance between both the places 80 kilometers, and it's difficult for the wife to travel accordingly. And considering the same, they shall be stay of all further proceedings. Take out hand summons.
Please.
Yes, this is matter on 17.
17.
Yes, next.
Preliminary hearing, seal number 19. 8.1.
Transaction laws. I seek permission.
My lord.
Withdraw the description. I seek permission of the court to withdraw the description.
Yes.
In the memo.
What is this?
Guidelines are produced.
Why guidelines you have produced?
My lord, may I submit, my lord?
Yes, what the court asked is, what happened to their application? What did you do with that?
Yes, my lord. My letter received by me. Sorry, my lord, I am due to net issues. I am outside. I am from car. I am doing so. I am kindly pardon me. My lord, document number 4 is a letter issued by me, in which, my lord, 3 applications were already forwarded to state government for fixing the inspection date, whereas in 2 applications were not yet received. And bar license, my lord, is we are only classifying the hotels. Bar license is not mandatory. In fact, they have to get a bar license for their own operations.
No, what is that, the limited relief, and what the court wants to know is, right from 2020, their applications are pending with you. Why were they pending from 2020?
Ours is only classification, my lord. Already we have given them 3-star category.
Mr. Counsel,
Mr.
Counsel,
my lord.
when
Please,
did you receive their application seeking the renewal of
in the year 2023, my lord, we have forwarded the same to state authorities.
When you have received application from them?
Receipt date is not there, my lord, but recommendation we have sent on 31/12/2018 we have sent once, and subsequently in 2023 we have sent again, my lord.
So now right from 20 they are having they're getting their the CL 6, I mean their 6A license on the ground that it is pending with you.
But it is not mandatory, my lord. On the contrary, for getting, for classification, bar license is,
Not mandatory for you, it is for the excise department, not for
yes,
you.
madam.
What I want
Yes,
to
madam.
know is, when was their application to you seeking the
2000,
translators?
yes, madam. 2018 we have received and we have sent it to state authorities in their 2023. The letter is there, madam, and the document number, I think, third one.
What
I have,
exactly does it mean? What exactly does it mean? Receiving an application in 2018 and sending it in
no, no,
2023?
because of the corona pandemic, madam, 2-3 years there was some lagging was there, but subsequently in there 23 was sent, and for inspection, if inspection is done, madam, it is only a categorization. We are not giving any license or we are not giving any permission, only classification from 3-star to 5-star, that's all.
Why you want to
We
withdraw?
are,
Just withdraw, no liberty. I'll just dismiss it as withdrawn.
Because I will file separate petition against the tourism department, because this is not comprehensive. Then make a comprehensive petition against tourism department and file it. That is the liberty I ask for.
So you are not pressing for the
Excise I am not pressing.
That
I have
I'll record.
sought-
As far as excise is concerned,
I have
no.
sought for liberty only to file against tourism department. Your lordship may please file my memo.
Where is the memo?
With the lordship's permission, there are 5 petitions, out of them 4 memos I have filed now. 1 memo is coming on the way. Take its signature and file it.
The memos were filed seeking withdrawal of the writ petition. In this writ petition, petitioner had made both the tourism department as well as the excise department as party respondents. It is stated that as per the memo of withdrawal, they want to file a separate writ petition in respect of tourism department, and as such, they're withdrawing this writ petition. As far as the relief against the excise department is concerned, no liberty is.
No liberty.
No, I just recorded. No liberty is sought. Accordingly, the writ petitions are dismissed as withdrawn, giving liberty to the petitioner to come up with an appropriate application in respect of the relief against the tourism department.
please.
For the appeal that I will advise for the appellate. As far as excise is concerned, I want appeal provision.
It is submitted that as far as then that liberty also you require, because I will file it here. That you have to ask. Now, if I say that you have not sought for, then you can't even file an appeal.
That's what I am seeking.
It is submitted that they have as far as the excise department is concerned, they have a right of appeal, and they will be going before the appropriate authority. Accordingly, the petitions are dismissed with the liberty to file an appeal against order of the who is deputy commissioner.
Against the commissioner, commissioner of the commissioner.
Against order of the commissioner.
Against the
order of
DC. Against the order of the revenue DC, appeal is to the commissioner of excise.
No, I am not recording about who is the appellate authority. I am recording whose order it is.
Deputy commissioner.
Against the order of the deputy commissioner, and to file a separate petition as far as the tourism department is concerned.
One memo I will file later.
Please do it. To give it.
Please.
For the excise department, Leonard, please give me an opportunity, Mr. Counsel, for the excise department, Leonard, additional advocate general has appeared, and for the central government, Mr. M.B. Kanvi,
Please.
Leonard Counsel, Mr. M.B. Kanvi appeared, and for the tourism department, so and so appeared. Right, to give your name. Yes, next.
Major.
Yes.
Water seal number 20. Rajendra Patil. Devirana.
That is the husband petition of. But if the respondent wife has filed petition seeking maintenance, 5,000 has been maintenance has been awarded. To recall,
How much is awarded?
5,000 has been awarded. To recover the settlement, they filed a recovery proceedings, initiated recovery proceedings. In the said recovery proceedings, matter is settled, and they both have decided to not rise together. Accordingly, he has taken law to along with him law, and he has since he stated that she will not stay in Gangavati, she will stay in Badari. He taken a house on rent and not he used to not work in Gangavati, used to up and down, and all basic not the rent etc. day-to-day expenses he has provided. In spite of that, not the subsequently, not after 1 year, again she filed recovery proceedings, stating that they are not taken care and they are not maintained her. And since from 2018, she is entitled for maintenance law. And the
according to you, from how long you both of you stay together?
Since from the September 2021, August September 2021 till the October 2022, September 2022.
So maybe she is not entitled for that period, where you are together.
And to show that not this period not, I have also transferred amount through PhonePe and Google Pay not. Those documents are also there. In spite of that, not since from the entire not, since 2018, she claimed 2,30,000 she is entitled. And apart from that, PhonePe and Google Pay.
No, like when both of you wanted to stay together, was there anything recorded by the court?
No.
And then what to do? There is nothing on record.
There is not. But not there. Since not the dispute is closed, as having they both are settled not they both ready to stay together. There is no more. Also,
what I am saying, it's all between the parties.
There is not.
Nothing is there on record.
There
is an order of maintenance granted against you.
There is not.
Nothing that you have recorded before the court, and that order came to be recorded about your, compromise and all. So as long as that order is there, whatever you say, you need to pay maintenance.
Similarly applicable to the respondent law. Once not matter is settled not, unless and until.
How it is settled in that? Where is she accepting it? Is she accepting? If she is accepting, I can understand. If she is not accepting it, it is for the person who say that there is a compromise. To prove that there was a compromise and you are living together.
Both parties are presented before the trial court in the recovery proceedings, and that is recorded. Both parties are settled, stated that we will stay together and dispute.
Where is that?
Please, page number.
Yes.
Okay, sorry. Okay, page number 48. The order dated 9/8/2021. Petitioner and respondent present, both parties agree to settle their dispute amicably. Hence, office to record the same, parties agree to rise together. Call on to record 14th August 21.
After that,
not the next page. The parties are settled the matter as per the advice of the council, mainly so and so, and where research and illustration. The parties have made a request before the local already noted on 9 is recorded on this day on 14th. Unless this order not the challenge or recall the said order not, once the matter is settled, how come not directly the initiate proceedings?
It is a matter which has been settled in local law. After having settled this gentleman has taken her to local law and convinced her for a momentary sake, and she agreed for that. Subsequently, after coming out from the court, you go and take home and pay the rent and everything, because he has already got married and having 2 kids in Gangavati. She is in marital her
then what are you supposed to do then? Was it not supposed to be brought to the notice of the court? Because when something is settled before the court, how do the court can now accept all that?
So for the
and that too, when in the till 2000, that when is order 14/8/2021, you said everything is settled and that is recorded. How are you entitled for maintenance from 18?
My lord, for the period 15/11/2018 to 15/9/2022. Arrears of maintenance, yes.
How can it be?
Because he has not paid anything. He didn't take
No,
my
the
call.
matter is settled. Whatever that order is honest in the eye of law now. When view of this order is by the Lok Adalat. How can the court order that? If at all you say that, in spite of it, the order or before the Lok Adalat, both parties are not separate, they are residing together, you have to file a fresh petition seeking maintenance. Basing on that earlier order, thereafter where you have entered into settlement, there can't be an order now.
When the order was not complied with the
What to do? But because you only went before the court and said, and basing on that, then what is passed? It has to be set aside. Or, in view of the subsequent circumstances, you should file a petition, fresh petition. Where is impute order?
But impute order, I have challenged the executive proceedings.
That's what, where is that? Any order is passed.
Yes, yes, passed. In that order, after the issuance of notice, not I have appeared. Since arrest note is not paid, I have been taken into custody. After deposit of 40,000, I have been released. Annexure A is not the proceedings which I have challenged. And in this proceedings, not before trial court, I am before the 40,000 before the trial court, and as per the interim order passed by the Supreme Court, again 50,000 has been deposited. Apart from that, 52,000 paid through phone pay and UPI. And
how much you have paid till now?
2,20,000 I for my calculation. That means their claim with central vehicle is 2,30,000 and 2,20,000 I for my clients. On record is not the 90,000 and 52,000. 1,40,000 is on record now because it was paid before the court.
So what is to be done now?
Since I have already taken care, I have paid.
Then you will recover all that. You want all that back?
Neither one says not staying not saying not unnecessary not, and still today not she in contact with them not the petitioner. She used to talk whenever whatever needed shopping etc.
No, whatever. Then you file a memo before this court on what all the amounts that you have paid.
No, I have filed.
Where is that? Page number?
Memo of calculation.
I too have filed memo.
Where is that?
Earlier memo he has filed this.
Memo of calculation dated 20th yesterday.
16/6/2021, 13/12/20. When is the impute order?
Impute order not the settlement not.
No, settlement before the Lok Adalat is when?
On 14th August 2021.
14?
14/8/2021.
14/8/2021.
Earlier site plan is 15/11/2018.
So 14/8/2021. So 6,000, 5,000. 14/8/2021. That is, so first 6,000 what you have shown is much prior to that.
Before that, she used to talk, she passed.
Understand what the court is saying. Looking at your calculation memo, 16/6/2021 you have shown 6,000. That we need not consider now because that is before the settlement. Later all the amounts are, so you have to deduct this 6,000 from 52,700.
46,700.
From September 2021 to October 2022, you have paid 80,000.
Every month
Then you are saying about 2 lakh something. Where from you say that? One minute actually.
First page. First page. That no
First page.
Maintenance paid in criminal 349. That is an impute proceedings. 90,000 as
when is it? After the compromise or before
after the compromise? Not after she initiating fresh recovery proceedings. The trial court warrant has been issued. There not I have deposited 40,000. And after the challenge before this on the court, this on the court granted interim order.
Yes, Mr. Counsel, what you say?
50,000 again here before this on the court. That has been withdrawn already from the response.
Which one, mine?
What do you say now?
The same law.
You are not. He is not. He need not pay the money.
So this item number 3, my lord, amount from September 2021 to October 2022.
Stay is granted in this?
Stay granted subject to deposit 50,000. That has been deposited before the court law and the same has been withdrawn. Already they have withdrawn.
But this 80,000 has not paid at all. He didn't see me at all. Simply here, my learned counsel is.
So how you paid all this amount?
80,000 not through cash law.
That anyhow we cannot consider no. Other than 80, what is that you have paid?
Other than 80, not 48,000 and 90,000.
90,000, how you paid?
Not so before the trial court no.
So 90 and before this court?
Before this one, 50,000 and before trial court
90,000.
40,000.
40.
Together 90,000. And through UPI excluding 6,000, 48,700.
That is phone pay.
Phone payment.
Yes.
1,38,000.
he fell in hospital and requested her to transfer some amount, asking someone. Again, she twice on phone pay, she's transferred amount. Once 10,000 on 5/6/2024. Is there any calculation amount? Then 13,000 on 14/6/2024. Totally 23,000 she has transferred to him because he is sick and got admitted in the hospital. That way, that kind of attitude both are showing. But since he got married and settled with some other lady, having 2 kids, he is totally
He has not
neglected.
obtained divorce,
No divorce.
and you are married, you accept that.
Because initially she stayed only for 1 or 2
You
years.
married or not?
Married now. Since
Then,
parties
without obtaining a formal divorce, how can you get married?
parties are normal.
Even at least he could have sought for her permission.
No,
Even that also.
in parties or membranes, they don't have to, take divorce from the wife in their own way. They don't take.
In their custom, at least in the custom they have to take,
But he has not taken.
No.
Then.
But to see, not religion, not stay together in the
Stay
in Karnataka.
in that case, you can't take divorce. So, what about this recovery now? How will she pay you back? Anyhow, you have done what you are supposed to do. You have got married second time without any procedure and all. Without paying any further amount, will say that you are not entitled to pay. You don't have to pay, and she is not entitled for it. Forget about the recovery things. Get instructions from your client. Tell him that. Unnecessarily, if he starts with this, so many other things will come.
But on recorded statement, he has taken what he has
He has taken what I'll record is. What I'll record is like something like you say you have given something, she says that she has given something in all this. As far as the future thing is concerned, she will not entitled. That's what I'll record. Without any return of the money and all.
My lord, she is entitled for maintenance, balance amount 1,16,000.
I'm saying that you can't implement it. Where is a question of balance amount? In fact, I am arguing for you and telling him that don't recover.
So that the amount what he has mentioned has not.
Let's forget about it. Whatever is the amount, you are not entitled. In view of the Lok Adalat award. And already you are so and so amount from 1.5 lakhs whatsoever paid. Even the amount that you have given 20,000 is deducted from that. Another 1,30,000. If this court holds that you are not entitled, then he can recover it from you.
So I am still entitled out of 2,30,000.
You are not understanding.
Right.
I am saying you are not entitled for that at all. You cannot recover in the light of the order passed by the Lok Adalat. That order of maintenance that is granted is not honest in the eye of law. There cannot be any execution. If, according to you, that something else has happened and that whatever award that is passed by the court, as per that you both of you are not staying together, then you are at liberty to initiate appropriate proceedings. Sir. Please come. Where is the order dated?
Not the order, including proceedings itself and including proceedings in the execution proceedings. Criminal Justice number 349 of 22.
Page number.
Annex A, page number 12. The entire proceedings itself not a short part.
The petition is before this court questioning the execution recovery proceedings initiated by the wife for recovery of the maintenance that is granted in criminal miscellaneous number 352 of 2022. Dated?
That's on 22/9/2018.
What is the criminal miscellaneous number?
45 to 18.
That's what?
45 of 18.
45 of 18. Dated?
22/9/2018.
22/9? 2018. The court, by virtue of the said order, granted maintenance of an amount of rupees 5,000 to the wife. In the year 2021, when the wife had initiated the recovery proceedings
In
in criminal miscellaneous 326 of 2018, on 9/8/2021, it is submitted that the parties want to stay together on 14/8/2021. The same was recorded before the Lok Adalat. It is the case of the husband that thereafter they are living separately, they are living together, and in fact, the husband has been taking care of the needs of the wife. Now, the wife had initiated the recovery proceedings right from 2018, and the order, in fact, the petition is remanded, and in those proceedings he has paid certain amounts. And even before this court also, stay was granted on payment of on condition of deposit 50,000, and accordingly he has deposited, and both the amounts she has withdrawn. He submits that when the order that is passed in the criminal miscellaneous 326 of 2018 culminated in the Lok Adalat order dated 14/8/2021, she cannot recover the amount of maintenance that was granted. He submits that it's a pure abuse of process of law. Learned counsel appearing for the respondent submits that the wife, both of them are not residing together. He has just submitted before the Lok Adalat, and thereafter they never stayed together. And it is the case of the husband. In the case of the wife, counsel for the wife that if the husband has an obligation to maintain the wife, which he has failed to do so. As such, there is no illegality with the execution proceedings that are initiated by the wife. Next para, having heard the counsel on either side, there is a material on record. Earlier, the court, that 2018 number, in criminal miscellaneous 326 of 2018, had granted maintenance of 5,000. Thereafter, that came to be compromised between the parties, and an award is passed. The award is passed. That award was never challenged on any of the ground, but simply she files a petition for recovery of the amount which she is not entitled to. It is not her case that where is that recovery proceedings initiated legally?
Present or earlier?
Present.
Present is not initiated. Petition.
Petition she might have
Petition,
filed.
please. Annexure. Email.
Page number.
60.
Huh?
60. Criminal misdemeanor 349 of 122.
Page number 60.
60. Here in last page, page 62. She says she is attacked for recovery of arrears to like 37 from 15/11/2018 till 15/9/2022. Tab number 2, my lord.
Now, when award that is passed is executable, award is executable.
In view of the Supreme Court judgment.
Not easy.
It's a case. No, we'll ask, then we will do one thing. We'll ask the trial court to decide this issue.
Please, no.
That is better.
Please, no.
Instead of relegating the parties.
Not again, unless that order challenge or recall one. She cannot direct any such question.
No, we'll see that. No, an award is passed that what is it?
It is not her case, sir.
It is not.
Her case.
It is not her case. No, not really. She has filed the petition stating that the husband has not taken her back and taken her back, and the fraud is played on. It is a case that the husband has not taken her and played fraud on her. In that event, she should question the said compromise, the said award passed by the Lok Adalat, which she has not which she has failed to do so. In that view of the matter, unless and until that award passed before the Lok Adalat is questioned, she cannot maintain, she cannot seek recovery of the maintenance from 2018 to 2018 to 2022. 2022 of 22. Further, if it is her case that the husband, in spite of an award passed, that the both of them are not residing together, and the husband had failed to maintain her, she is always at liberty to initiate fresh proceedings under 125 CRPC, seeking maintenance. The husband has argued with uh, fresh maintenance. In that view of the matter, the order, the writ petition is allowed, and the wife is not entitled to recover the maintenance as per the order passed in criminal miscellaneous 321 of 326 of
345. First order.
first order is
Criminal Justice of 45 of 2018.
first order is 20
45.
45 of 2018. Accordingly, writ petition is allowed.
And also, the pendants of this petition, she again from 23 and 24, again she filed fresh proceedings. In that, again, no warranty issued, again I have deposited, that I have satisfied. It is going on or continuing?
No, it will not go no, from now on.
Please, great.
Seal number 21, CA chapter. For the seal number.
Husband's petition